everybody. Welcome to our fifth episode of what we're now calling the Re-Federalist series. I am Brady, also known in some corners of the internet as Warhamster. Joining me today is my good friend, constitutional mentor, Mr. Constitution himself, Douglas V Gibbs.
Thanks for having me.
Always a pleasure. Today we're going to do the first of probably 2 or 3 videos taking a look at recent Supreme Court decisions. I think this is going to be something we're going to do every quarter when SCOTUS Supreme Court issues its decisions, but there was a lot of really big landmark cases. We're going to hit on 3 cases today and hopefully hit a couple of other big ones either tomorrow night live on For the Republic, and we'll give you details of where that is at the end of the show, or we may just do a studio recording for the next couple of episodes because there's a lot to unpack with what the Supreme Court's been doing. Some of it good, some of it not so good, and inconsistent. I say the rulings have been very inconsistent with what we consider the original intent of the Constitution, and that's what we're going to do a little bit differently. I mean, you can go to any YouTube channel and find someone to give a legal breakdown of these cases, citing case law. What we want to do is talk about whether the Supreme Court is making their decisions based on the original intent of the Constitution or not. And who better to help me with that but Mr. Constitution himself? You ready to jump in?
Ready to roll. Let's do it.
All right. The first case we're talking about, and it'll be related to the second ones, really regards the administrative state. As everyone knows, the government has been encroaching on our individual liberties for the better part of 2 centuries. And one of the ways they do that is through the executive branches. They create their agencies, and the agencies, become a government unto themselves, which is very problematic because these are not enumerated powers in the Constitution. So we've had a number of cases that are seeking to challenge that. The first one is known as SEC, the Securities and Exchange Commission, versus Jarkesy. And Jarkesy, well, I'll get into the details of that. Interestingly enough, Doug and I on Alan Meyer's show For the Republic back on December the 3rd, 2023, we talked about this case right after they'd had the oral arguments. So 6 months ago, they talked about it, and 6 months later, they come up with a decision. I thought I'd play about 4 or 5 minutes, given the background of that, of what we did in December. And, we did a decent job on it. And that'll lead us into today's arguments, and I'll get Doug's opinion then. I do have a very fun story. This is a Supreme Court case that kind of slipped under the radar for most people. And it's known as the Securities Exchange Commission versus Jarkesy, or Jarkesy. And what happened is this guy Jarkesy, the Supreme Court actually debated this on November 30th, so just a week ago. Jarkesy was a financial advisor. The guy comes from my world, and he ran a couple of investment funds with about $24 million, and the SEC came in and said, we think you were misrepresenting, overcharging, et cetera, and you broke our rules. We're going to enforce it, and we're going to be the judge, jury, and executioner. So Jarkesy made an interesting argument against it, saying that's not the way it works under separation of powers. The SEC, Securities and Exchange Commission, they can't create rules. That's a legislative function. They can't execute rules. Well, they can if the legislative branch could.
They're backed by law.
But they certainly don't get to adjudicate them and be the judge, jury, and executioner as well. And it gets kind of fun if you really look into the legal arguments here. And this has a little bit of a San Diego tie here. So one of the things he quoted in the arguments in front of the Supreme Court was a case that was just settled in 2019 called Lucia versus the Securities and Exchange Commission. And if you're from San Diego, which a few of our listeners are, and I was, Ray Lucia, it was another financial advisor, and I'm not going to slander the man, but he was accused of basically defrauding some of his clients. And interesting. Just a little side note with Ray Lucia. If you live in San Diego, you've been exposed to his commercials and his infomercials for years. He also happens to be the father-in-law of a really bad quarterback by the name of Ryan Leaf, who married into the family when he got done with football, was trying to become a financial advisor, as if anybody in San Diego would ever trust a dime of their money with that guy. But that's Ray Lucia for you. But Lucia had appealed the decision, argued that the administrative proceeding was invalid because the administrative law judge had not been constitutionally appointed. According to Lucia, administrative law judges were officers of the United States and thus were subject to the Constitution's Appointments Clause. Under this clause, federal employees deemed officers of the United States could be appointed only by the president or head of a department, and the SEC did not do that. Well, the nuts and bolts of this case that was just argued last week is that these federal agencies, the SEC in this case in particular, has no constitutional right to exist. It cannot write law. It most certainly cannot be the judge, jury, and executioner. And these people are being deprived of their Seventh Amendment rights to being judged in front of a jury of their peers. And it is a fascinating case. There was an article in the Atlantic. See if I can find that real quick. I've got a lot of details on this if you want to get it. The article in the Atlantic was the case that could destroy the government. And this was written by a leftist that's saying, oh my God, if the Supreme Court actually rules that the SEC has no right to exist or to execute the powers that it's been executing, then the entire administrative state could be dismantled overnight. And their fears are valid. Now, the arguments at the Supreme Court are interesting because the usual suspects of Kagan and the three far left judges are basically stating that this was actually talked about 60 years ago. And I do know the case. I have it here. But there's a case that basically said that, they're in a much more progressive court, they had ruled, and none of these cases have been brought for 60 years. We have a different court today. And the three consistently conservative judges, their arguments were very much for, well, let's start having these conversations. Where it gets interesting is Kavanaugh and even Amy Coney Barrett and Roberts, the three middle judges, seem to be leaning against the SEC in this case. So the possible implications are fascinating. Obviously I don't think they're going to go too far, but I bring this up because I'd love to hear the opinion of Mr. Gibbs and Myers on this topic.
Well, from what I know, from what you said, without reading the cases and getting into it, sounds the plaintiff's argument sounds legitimate. I would agree. And I've actually said where in the Constitution does it give the federal government the authority to have an SEC. Now, that said, before everybody starts freaking out, oh my God, you want chaos to go on. Well, if it's necessary, then let's propose an amendment and make it legitimate. If that's it, first of all. Second of all, when it comes to these agencies, now this idea of them having the power to make rules independently, regardless of what the law said, has never been constitutional. It's been a problem. And that argument there has been before the Supreme Court a number of times, even lately. And matter of fact, EPA just got struck down, what was it, 2 or 3 months ago, over making arbitrary rules that did not necessarily follow legislation. So this could get interesting if it gets any legs. But like I said, it's a legitimate argument. I agree.
Okay, so that's our background. I'm guessing your opinion hasn't changed a whole lot.
No, but I did want to bring up something that I didn't bring up, I don't believe, at that time. And it was also a legitimate argument by the plaintiff, and that is the Seventh Amendment. And you brought it up as well. And that is the idea of trial by jury goes all the way back to the Saxons. This idea that
an organization or a government group or a government body cannot just be judge, jury, and executioner, as you put it, is enumerated in the Constitution. And the Seventh Amendment, A, has always been judicially considered from the very first moment to apply to both the federal government and the states. B, all of the state constitutions have language almost exactly the same, and in some cases verbatim, as the Seventh Amendment. And what the Seventh Amendment basically says is in layman's terms, is if it's not a small claims court case, the amount of money that's involved, the injury, the cost of the injury is greater than a certain amount, then, and at the time it was $20, then the right of a trial by jury shall be preserved. Trial by jury is necessary. An agency can't be your jury. A jury of your peers, or as it says in the Constitution, an impartial jury is required. And the other part that's important too is once the facts of the case are used, the evidence is used in that case, double jeopardy. They cannot be reused in another case against you. So these are very, very critical things that this case addresses. Go ahead.
Yeah, and even adding a little bit more to the history of that, everyone thinks the Revolutionary War was fought over taxation. Well, yes, but one of the major issues was the fact that the English were taking the colonists who were British subjects or citizens, I guess British subjects, and they were trying them not in front of a jury of their peers, but in admiralty courts and laws of administrative justice, where it's more of a tribunal than it was a trial. And that's
no jury, and the judge was directly appointed by the nobility rather than out of the local pool of officers.
Yeah, and that's why the word peers is so important when you do that. And that literally is one of the major causes of the Revolutionary War. And that's why
James Otis. That's where James Otis kind of got his fame. James Otis in 1761, who because of the writs of assistance, believed that they were unconstitutional, that they were just general warrants, and he quit his job as a judge working for the British Empire and began to defend the colonists. And he has this famous speech before the court where he basically, talks about man's home as his castle, but he gets into also these ideas of juries and warrants and all of this other stuff. And he's known as the grandfather of the revolution. This issue, or at least a part of this issue, was the spark that began the revolution.
Absolutely. So it's and you see it in every single state constitution language about the Seventh Amendment. We're very similar to the Seventh Amendment, which is also crafted from the Virginia State Constitution, which derives
1776.
That derives straight from the English Bill of Rights. So there's a long history to this. It's an important subject, and what's happened, we've had the administrative creep over the last century plus. As all these three-letter agencies get bigger and bigger, they started becoming, they started writing laws. Congress would say, okay, SEC, go make a law. Here's a big picture. You write all the fine prints. Then they would go out there and they would be the ones who investigate whether you broke their law. And then they come back and they say, okay, now we're going to render judgment upon you. And it's a separation of powers issue. That the executive branch is now legislating, executing, and then, adjudicating, and that's really where the issue is. Now, the ask from Jarkesy, I found out that it's pronounced with 3 syllables. I've been saying it wrong for almost a year. It is Jarkesy. He asked, we talked about the Seventh Amendment issue, but he was looking for the Supreme Court to rule even more broadly than they did. And as I said in that video 6 months ago, this is a court, the Roberts Court, that does not do big sweeping changes. They do everything incrementally. Roberts is so concerned with his legacy He does not want to be known as some rebel who flipped the entire legal system on its head. He does everything in increments. So we didn't get the big ask. And you could tell that at the oral arguments at the Supreme Court back in November, is that the question was almost all focused on the Seventh Amendment issue. And here's what they wrote in the decision. It says, we consider whether the Seventh Amendment permits the SEC to compel respondents to defend themselves before the agency rather than before a jury in federal court. Doug, you want to touch on whether this should be a federal court issue or a state court issue, and give the 30,000-foot view of that as opposed to the deep dive?
Well, the federal courts actually, in this case, I think should be taking it because it's about federal. It is about federal authority. The thing is, the federal authority that's being used here is not enumerated in the Constitution. It's not given. Anytime the federal government or a part of the federal government, according to Article 3, is a party to a case, it is a federal case, whether it's regarded as something that's authorized or not, because the federal agency or the part of the federal government is at stake here. Now, that all said, the question really comes down to the administrative state's existence. And are these alphabet agencies even constitutional in the first place? And I'm going to kind of tip everything on its head here, because this is something you've heard me say, but most people are not aware of. And we hear about it, right? The deep state and the administrative state and all that. We hear this all the time. And this is nothing new. The Federalist Party under Hamilton had, built this nice little rat's nest inside the bureaucracy, even way back in the 1700s. And when Thomas Jefferson became president, he felt compelled to fire about half of the bureaucracy, the Federalist Party half. And what's interesting, to show you how powerful and how important that bureaucracy, that administrative state is to tyranny, once Jefferson had rid the federal government, federal system of that rat's nest of bureaucracy, within 20 years, the Federalist Party was gone. It literally began the dismantling of that particular tyrannical party.
Unfortunately, it was already embedded in the Supreme Court and the federal court system. And
the nationalist-minded Federalists were there, and that's what they did. They retreated to the stronghold of the courts, as Jefferson put it, where it'd be more difficult to dislodge them. We can get to the midnight judges, all of that. But here's the key. From a constitutional standpoint, should these agencies even exist? Should the federal government have agencies with policing powers? Because that's basically what they are.
Yeah, and it's an important question. Now, the SEC was created by acts of Congress, and they were necessary acts. And I'll speak from experience. I've been under SEC regulation for most of my adult life as a licensed security professional. I still have licenses. And the SEC, most of the people there are straight shooters. They really want to uphold the letter of the law, and they do a pretty good job of catching most of the bad actors. Where the SEC sort of runs afoul of that is, at the top of their food chain is they're politically appointed. And when you get the major Wall Street firms, the big players get involved, it seems that the SEC only gives them slaps on the wrist and are never held accountable. And that's because it's been a politicized agency, like almost all of the three-letter agencies or the government agencies. They are politicized, but most of the rank and file people there, they're some of the best. These are people you'd want to have live next door to you. They are straight shooters and good people.
Yeah, but from my point of view, the question is not whether or not they're good people, whether or not it's necessary. Is it constitutional?
Well, exactly. So Congress creates the Securities Act of 1933, the Securities Exchange Act of 1934, and the Investment Advisors Act of 1940. I've had to memorize. Everybody who's a licensed securities professional has had to memorize the reason these things were put in place, and there was a good reason, because under the Federal Reserve in the 1920s, the crash of 1929, that created a big part of the Great Depression. There were an awful lot of bad actors selling securities, basically lying to their customers and screwing everyone over. So these acts were well written and they were necessary. But the point you're making is, did Congress have the authority to do that, or did it require an amendment?
And in the end, it did require an amendment. And not only did it require an amendment because the authority over securities. Well, let's back up a little bit. So, the securities of the government, there is an authority, but securities in the private sector there is not, and there is a difference between the two. But even more important when it comes to, let's see, I was to provide for the punishment of counterfeiting the securities and current coin of the United States. So where securities is mentioned in the Constitution, it is federal securities, bonds, things like that, not something that's in the private sector. Private sector is hands off, none of their business. But the other key part is this. Federal law domestically was a no-no. It's up to the states to handle local stuff. However, bankruptcy is in here. Why? Because it influences the country as a whole. So I could see a necessity for what the SEC does. I understand the necessity, and I think that if the founding fathers were witness to what had happened, they would have been fine with the creation of such an agency once there was an amendment in place granting those authorities. And when it came to these alphabet agencies in general, now I'm going to leave the SEC. I'm going to talk about them in general. You know, your SEC, your ATF, your IRS, your FTC, and so on and so forth. Or I'm sorry, FDA, is this. And this is in Article 1, Section 8 of the Constitution, about halfway down, a little bit past halfway, that particular section. And the words, the Congress shall have power, is assumed before each of the twos for those of you playing along and keeping score. And it says, the Congress shall have the power to provide for calling forth the militia to execute the laws of the Union. The laws of the Union, federal law, if it was to be executed, was the job of the militia. Now, I know the word militia has been maligned by the left. What I'm talking about is a constitutional militia. These are the local people who are deemed with protecting their communities, protecting their state. And what the job of the executive branch was to send its executive officer to work with the militia to then carry out these laws, if there are any federal laws that are internal. It was not the job of some policing agency, because remember, the founding fathers were scared to death. The people of that time, the citizenry, the populace, was afraid of a standing army being used against them. And when we hear standing army, we think Army, Marine Corps, so on and so forth. We think of a uniformed, soldier. We don't think of a government officer. But that's exactly what these agencies have become. They become standing armies that police the localities under the iron fist of federal rules. And that was never intended. Now, once again, if something's necessary, you've argued that the SEC is, then let's put it in the Constitution as necessary and let's write it up right. But generally, when it comes to these agencies by the federal government, it was very dangerous to allow them to be a policing body. And what has happened is, over time, these policing bodies have become their own rule makers and their own judiciary. And now you went into separation of powers. And once again, for those of you who keep in score, the words separation of powers is not in the Constitution. It is a concept that was well understood, written by Montesquieu, but it is in the Constitution in the way that in the beginning of each of the first three articles, it says that the powers of each branch are vested in those branches. Vested mean that it's exclusionary power to only to that branch, and they're irrevocable, can't give them away. So the legislative power is vested in a Congress. The executive power is vested in a president. The judicial power is vested in the Supreme Court and other inferior courts. So that's your separation of powers. So if the judicial power, which is the power to judge, to adjudicate, belongs only to the courts, and a part of that is a jury trial. And if you've got a policing agency, which already exists unconstitutionally anyway, carrying out those judicial activities, we've got a problem. And really, that's what this whole case was about. It came down to that.
Yeah. So Jarkesy, he ran a couple hedge funds. Just a little more background. The SEC thought it was fraudulent, so they brought a case against him before what's called an ALJ, administrative law judge. These are judges that aren't appointed in the traditional manner, and that's where the issue comes up. There's about 2,000 of ALJs who work for a range of federal agencies, and that's how these agencies have basically superseded the judicial system.
Yeah, and they're appointing their own judges basically within. And then the question comes to this, and I'm sorry to interrupt, this is important, is Congress, when it comes to appointing these judges, these individuals, these officers of the federal government, in the Constitution, and I believe I want to say it's in Article 2 or 3, but I can't remember off the top of my head exactly where it's at, but I'll tell you what it basically says, is it says that the appointment of officers begins with a nomination by the president and then must be confirmed by the Senate. However, it does say that Congress, by law, so it has to be a law that's in place that says this, may allow the president to appoint certain officers without it having to go through the full process of confirmation. Typically, these are minor officers. The Senate can't be sitting there for the first 2.5 years confirming thousands of people. So they basically, when you get to the minor officers, those that are 2-3 steps down, the assistant to the assistant of the assistant kind of thing, that gives the president the opportunity to appoint these people without it having to go. But it has to be, that position has to be indicated by law. So the question is, are these judges, were they given to the president to appoint without senatorial confirmation, and was that decided by law? And the SEC, if the president then, once they has the power to appoint, wants to say, okay, SEC, you appoint them because you're under me, and it's as if I'm appointing them, they could do that. But the question is, was there a law in place saying, hey, SEC, you can, but only because this law says you can? That's the question. And I have a feeling, based on the way they ruled, that no law exists. They have been taking it upon themselves to create these positions and appoint these positions.
Yeah, and there's no appeal. I mean, you're basically stuck in the water.
Yeah.
You have to take whatever they've written, the rules they've written and chosen to interpret the way they want to. They render judgment, and you've got no appeal. That's not that much different than the admiralty courts, that the English were doing on the founding fathers.
And what I was talking about is in the Article 2, Section 1, third paragraph is what I was just talking about.
Very good. So the SEC rules that Jarkesy's got to pay a penalty of $300,000 and disgorge $685,000 in illicit profits. Now, whether Jarkesy's guilty or not is not the point.
Sorry, Section 2. But anyway, go ahead.
Thank you. We do want to be accurate here. Because there's going to be someone out there who's going to fact.
Yeah, Article 2, Section 2. Let me read it real quick, just so everybody can hear it, because I want to make sure we have full clarity here. He shall have power by and with the advice of the consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers, consuls, judges of the Supreme Court, and all other officers of the United States. All means all, funny, whose appointments are not herein otherwise provided for, and which shall be established by law. But, and this is what I was talking about, where Congress can give the president the ability to, but the Congress may by law, once again, it has to be a law that's been passed by majority of each house and signed by a president in the past or at that time, by law, vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. So the heads of the departments also could do the appointing if a law says they can. But once again, there has to have been a law. The vesting or the creation, the appointment of officers, the creating of these offices can't be by, say, the SEC without Congress instructing that they're allowed to do this, and that being law, having been made law in the past. And once again, based on the ruling, because I haven't read the entire ruling, I'm going to go by and didn't do all the research that their staff made. But based on their ruling, it is I think a reasonable assumption that those laws don't exist. The SEC took it upon themselves to create these positions and appoint these people, and that's unconstitutional.
Yeah, so to give an example, we need the first Congress decided we need a Secretary of the Treasury, Secretary of State. You won't find those positions mentioned in the Constitution, but Congress was given that authority to create those positions.
Right.
Yeah. So, and just a little side note, I don't know whether Jarkesy is guilty or not. That's the moot point. One of the reasons I've always appreciated the SEC, which 99% of the time is very, very fair and has a tendency to protect the consumer. As a financial professional myself, you want people to be able to trust you. And if the SEC is cleaning up the bad actors as much as possible, that helps me do a better job, because people are going to trust that there is regulation. And that's one of the reasons the American markets are the most trusted in the world, is because the SEC has done such a good job policing the sell and trading of securities. So we're not here to bash the SEC. Yeah. And I'm not saying
I'm not here to bash them. It's just they're not supposed to exist. But anyway, go ahead.
So, yeah, well, they probably, and like you said, they probably need to exist. But if you're going to create them, go through the actual process of amendment.
Right.
So Jarkesy doesn't fight their decision whether he was guilty or not. He says, I'm gonna question the process. So he appeals to the conservative Fifth Circuit, and they ruled that under the Seventh Amendment he was entitled to a trial by jury, and the Supreme Court just upheld that. And we'll get to that. The other two issues that they could have looked at was whether the case asks whether it violates the non-delegation doctrine to give the SEC, but not the enforcement target, an unconstrained choice of whether to bring such cases in federal court or its own in-house tribunal. The last thing they were seeking is whether administrative law judges are insulated from removal by too many layers of protection. Because the Supreme Court justices were focused on the first issue, the Seventh Amendment issue, they did not render an opinion on the other two cases. So they did not, with their ruling, go as broadly as I would have liked to have seen and answer those other questions. The issue comes back to, there's a case in 1977 called Atlas Roofing versus OSHA, and that held that jury trials are not required when the sovereign sues a citizen over a statutory violation that Congress had the power to enact. Thomas talked about the public rights doctrine. The idea that agencies can adjudicate public rights without a jury cannot apply to any matter depriving an individual of property. That was Clarence Thomas's opinion on this. And so basically we're overturning Atlas Roofing, that it, just in not 50 years ago, they ruled you don't get a jury trial. And that's how much the court has changed in our lifetime.
And Justice Thomas at that point, he has been in this position much longer time, and he's got a staff he probably trusts more than he did early on, and he has had other cases to learn from. Understand when these, and this is one of the things that frustrates me, when these people are appointed to the United States Supreme Court, while it is the quote unquote highest court in the land, they are in the end still human beings. And as you have learned in your own life, I am sure that life is a journey. You're always a student. You will be a student till the day you breathe that last breath. And I think this is a great example of showing how Clarence Thomas is still a student. And he did recognize that, there needed to be an adjustment on his way of viewing this based on his studies. And so I actually congratulate him for that.
So Roberts writes the decision, and what he states in there, I'll read it verbatim. He says, a defendant facing a fraud suit has the right to be tried by a jury of his peers before a neutral adjudicator. He also said, allowing the executive branch to play the role of prosecutor, judge, and jury as in enforcement proceedings conducted by the SEC internally is the very opposite of the separation of powers that the Constitution demands. And that's almost verbatim what Doug said 5 minutes ago.
And that neutral adjudicator there is the big deal here. Part of what makes our system so great is the checks and balances, and one of those checks and balances is using neutral systems to judge. Now, that said, that it doesn't always work the way it's supposed to. You get these actors in there that are not neutral, and we can, refer to recent cases regarding a certain former president to even illustrate that. But overall, generally, our judicial system has done a good job at making sure that the juries, the judges, and the locations are as neutral as possible so that a person can get a fair trial. But how can you get a fair trial when the very agency who is accusing you is also the jury? And so this neutral adjudicator is an important part of it.
Very much agreed. And this ruling does not just apply to the SEC.
Right.
This is sweeping to all the federal agencies. EPA has been shutting down businesses for all kinds of rules, without a fair hearing. They basically determined something that wasn't pollution yesterday is pollution today, and now you're out of business with no right to appeal. And that's all changing. It is going to severely scale back the ability of the federal agencies to stick their noses in everyone's business. And this is going to be, it's a very sweeping decision. And like I said, I don't think it's as broad as it could have been. And that's going to lead us into the next case we're going to talk about, where they address some of those issues a little bit better. I think it's worth hearing what the dissenting opinion was. And, this was a 6-3 ruling. You can guess who the three that ruled against it were. They were all democratically appointed judges. Justice Sotomayor wrote the dissent. And she writes, and this is, picture yourself where she's coming from. She is defending the administrative state. She writes, for years, Congress has allowed an agency to impose civil penalties and she warns the majority's decision would unleash chaos. She criticized the ruling as a power grab. And I would say it's just the opposite of a power grab. It is taking the power away from those who grabbed it. She writes, the majority today upends long-standing precedent and the established practice of its co-equal partners in our tripartite system of government. And again, I would say just the opposite just happened.
And notice the use of the word precedent, and precedent is so important to the left, tyrants, whatever you want to call it. And I use this often, and so I keep it in mind for exactly this reason. 2019, Gamble versus the United States, where Clarence Thomas wrote that in his judicial opinion, that if a ruling or an opinion is egregiously unconstitutional, it must be overturned. Precedent, in other words, isn't in stone, and it can and should be reversed should it turn out to have been a bad precedent. And Sotomayor, in her opinion, is all over the precedent. Oh, but it's overturning precedent. If the precedent was wrong, the precedent doesn't matter. Let's do it right. Let's go with what the Constitution says, not what precedent says. I'm assuming the other dissenting judges was Kagan and Jackson.
Yeah, I don't know how you do it, Doug. That's an incredibly accurate guess.
Yeah,
it's pretty predictable. And some of these cases, we know. I mean, I don't know. You already know who's going to vote which way.
Yeah. Every once in a while, you'll see Gorsuch or Kavanaugh and Amy Coney Barrett kind of go one way or another. Alito and Clarence Thomas are pretty secure in where they stand. Now, you'll notice I just went through all of the justices. I was reading an article years ago that said it was statistically impossible for the average person to name all of the justices. Well, maybe not so much, but anyway, continue, please.
Yeah, we watch this quite a. I mean, we pay a lot of attention to
Yeah.
the Supreme Court, and again, just to reiterate, we're looking at these cases not from the precedents, which is case law is how our legal system runs, and not necessarily that really may not have been exactly how it was intended.
Right.
We look at these, how would the founding fathers have felt about how our current Supreme Court is ruling? Is it following original intent? And how do we discern what original intent is? Well, we listen to the people who were there. You've got the source documents, things like Madison's notes at the Constitution. We look at the Virginia ratifying convention, the New York ratifying convention, the Federalist Papers, the Anti-Federalist Papers. You look at the other state constitutions. What were the discussions in the state courthouses? And Doug and I, between the two of us, we've read just about every word of that, of that period. And that's how we can't get into their minds, but we got a pretty good idea of what they thought at the time. And it's been warped and twisted for the last 240 years. And that's when we talk about call the show the Re-Federalist, we'd like to get back to a system of federalism with limited government that exists only to preserve our individual liberty and God-given natural rights. And that's our mission here. So that case was interesting. It was, we've been talking about it for over 6 months. The decision finally came down, and we got a good result. And as I said 6 months ago, the Supreme Court isn't going to take the big chunk out of the pie. They're going to beat back the administrative step, one bite at a time. The next bite they take was people have been talking about this one recently. They overturned what's known as the Chevron Deference. And the two cases that were brought were called Relentless versus Department of Commerce and Loper Bright Enterprises versus Raimondo. And what is the Chevron Deference? This was a Reagan-era EPA interpretation of the Clean Air Act. It was generally hailed by the conservatives at the time. The ruling eventually became a target for those seeking to curtail the administrative state, who argued that courts, rather than federal agencies, should say what the law means. That judge-made doctrine holds that when a statute is ambiguous, the courts must defer to an agency's reasonable interpretation of the ambiguity, even if the government's interpretation is less plausible than the opposing parties. What they're really saying, Doug, is trust the experts. We'll talk more about how did trusting the experts work for us in 2020 during COVID. The experts are never wrong. And I've talked about this a bit, and I'm going to be going into more depth of the idea of technocracy. We talk about who really rules the world. You've got these bureaucrats and technocrats, and they'll sit there in their corner offices and they make up all these rules, and they never spend any time in the real world. And we're the smart ones. We get to tell you, how to, what to do, and that's just.
And they make sure the rules are written just broadly enough that the interpretation can go anywhere they want. And they love interpretation. They love this idea of interpreting things, because as I like to tell a story with my bilingual wife, who was the interpreter between my mother-in-law and I, she's got the real power in the conversation because she's the interpreter. She's the one deciding what was said. And whether or not she's honest about what was said or what is written, that's where the real power lies. And we have these interpreters of the law and these interpreters of the documents that accompany the law, like the Constitution, saying, this is how we've interpreted, and then that becomes the precedent interpretation. And that's where we run into trouble. And because the narrative, the interpretation, is usually what benefits what they ideologically believe in most.
Jumping back in, with the going back to the Chevron Deference, what it meant is
Right.
what it did is it tilted the playing field in the government's favor, in favor of administrative law cases, and it's been doing it for 4 decades. Those of us who are more than 4 decades old have noticed that the federal government has been, sticking their nose further and further into everything. We all know people whose businesses have been shut down or, altered dramatically because of some new regulation that a pencil pusher in Washington, D.C. writes. And fortunately, the Chevron Deference is no more.
And ex post facto goes out the window. Things are supposed to be grandfathered. But if they say no, then it doesn't happen. And ex post facto, by the way, after the fact law, which is not allowed at the federal or state level, is mentioned in Article 1, Section 9 and Article 1, Section 10 of the Constitution. And that's part of the danger here. Continue.
Well, here's an interesting fact about this: the Chevron deference, the case of Chevron versus Natural Resources. It is the second most cited case in American legal history.
Interesting.
And it's been around 40 years, and it is now gone. Those on the other side of the Chevron doctrine, they say it empowers an activist federal government to serve the public interest in an increasingly complicated world without having to seek specific congressional authorization for everything that needs to be done. And that's the right criticism. It is not the job of the executive branch or its agencies to create law. And we've got a Congress that has been doing this consistently for a decade or two. In the wake of the Chevron deference, is handing over the rulemaking to the specific agencies because they're the experts. And Congress gets to punt and not do their job. Do I have the decision itself? I've got it over here. Roberts explains in his opinion for the court on Friday, it's inconsistent with the Administrative Procedure Act, a federal law that sets out the procedures that federal agencies must follow, as well as instructions for courts to review actions by the agencies. The APA, Roberts noted, directs courts to decide legal questions by applying their own judgment, and therefore makes clear that agency interpretations of statutes, like agency interpretations of the Constitution, are not entitled to deference. Under the APA, Roberts concludes, it thus remains the responsibility of the court to decide whether the law means what the agency says. Now, we've got what's called it's an antagonistic justice system. You're being accused of something, you have the right to face your accuser. And the Chevron deference basically said, well, the accuser gets to make the accusation, and then he gets to decide if the accusation is legitimate. I mean, that's how silly it's been. If you really break it down that simply. Roberts rejects any suggestion that agencies rather than courts are better suited to determine what ambiguities in a federal law might mean, even when those ambiguities involve technical or scientific questions that fall within an agency's area of expertise. Roberts emphasized Congress expects courts to handle technical statutory questions, and courts also have the benefit of briefing from the parties and, quote, friends of the court. And it's really what we're saying is that both these cases we're talking about, both SEC versus Jarkesy and the Chevron deference cases, are basically unwinding the ability of our federal agencies to act as judge, jury, and executioner. And this is victory.
The administrative state and judiciary are very good at, by the way, of creating ambiguity sometimes where they don't exist. And because it's expected there's going to be ambiguities, and they'll claim there's an ambiguity when there isn't sometimes, and that the law is clearly written. This at least also helps guard against that as well.
Clarence Thomas writes a concurring opinion. And anytime Thomas does that, it's worth reading.
Absolutely.
Clarence Thomas is it's definitely one of my two favorite current Supreme Court justices. He's what you call a textualist. He reads the Constitution word for word. I prefer an originalist, which goes a little bit further than Thomas, because when you get into the intent. But he goes with the letter of the law, which is much better than the activist judges we've seen better part of a century who want to reinterpret it as
right.
That's not what they meant, and that's not what it says. At least Thomas gets half of it right. He goes to what it says. Would you agree with that one?
Yeah, and I think Alito probably gets closer to being an originalist, not purely, but closer than Thomas. But Alito, and I'm going to guess your other favorite would be Alito. Alito and Thomas are definitely my two favorites as well. I think that they take it seriously what the Constitution says.
Yeah, and Gorsuch can pleasantly surprise us. He's not as consistent as those two, but every once in a while, he's a brilliant legal mind.
Yeah.
So let me read Thomas's just a summary. He penned a brief concurring opinion in which he emphasized that the Chevron doctrine was inconsistent not only with the Administrative Procedure Act, but also with the Constitution's division of power among the three branches of government. So Thomas nails it, everything we've been talking about. He says the Chevron doctrine requires judges to give up their constitutional power to exercise their independent judgment, and it allows the executive branch to exercise powers not given to it. I mean, that's Thomas making our argument for us. So,
and that gets back to these alphabet agencies having too much authority, too much power, too much ability to unilaterally make their own decisions, and those decisions regarding your guilt, your punishment, and there just is no authority for them to unilaterally do these things.
No, there's not. They've been acting like there has been, and that's why we had what we call the administrative state creep, and it's gotten to be a problem.
Creeping incrementalism is what I've been calling it. So yeah,
it's a good term. Gorsuch also wrote a concurring opinion, and what he said is he emphasized that today the court places a tombstone on Chevron no one can miss. In doing so, the court returns judges to interpretive rules that have guided federal courts since the nation's founding. He sought to downplay the impact of Friday's ruling, contending that all today's decision means is that going forward, federal courts will do exactly as this court has since 2016, exactly as it did before the mid-1980s, and exactly as it had done since the founding, resolve cases and controversies without any systemic bias in the government's favor. It's a little naive in his interpretation of what the courts have been doing for the last century, but he understood the importance. Can you guess who dissented?
Yeah, I have a feeling it's that same three and possibly a fourth, but those same three, Jackson, Sotomayor, and Kagan, are obviously in the group.
Right again, Douglas. Kagan writes, he read a summary of her dissent from the bench. She was sharply critical of the decision to overrule the Chevron doctrine. Congress often enacts regulatory laws that contain ambiguities and gaps, she observed, which agencies must then interpret. The question, as she framed it, is who decides which of the possible readings of those laws should prevail? For 40 years, she stressed, the answer to that question has generally been the agencies, with good reason. Agencies are more likely to have the technical and scientific expertise to make such decisions. Trust the experts.
And it also goes back to what I said earlier. They create ambiguities where they don't exist. And she's saying, but they should be able to do that.
She goes on, 40 years, she stressed I've decided that. It has been applied in thousands of judicial decisions. It has become part of the warp and woof, where'd you come up with that terminology, of modern government, supporting regulatory efforts of all kinds, to name a few: keeping air and water clean, foods and drugs safe, and financial markets honest.
I was expecting her to say the Vorpal blade went snicker snack at this point. Yeah, you're right. I don't know where. Apparently, she's a Jabberwocky enthusiast when it comes to her choice of language.
Yeah, and there's from a practical standpoint, getting rid of the Chevron deference, it's going to make the courts work a lot harder, and hopefully they're going to be a little bit more discerning, and hopefully we have fewer regulatory cases brought forward, knowing that the burden, the burden of these agencies to bring forth a case on somebody just got raised. So you're not going to have, the EPA or someone like that just slapping a fine on everybody they want. They're going to have to be a little bit more judicious in what they go after.
And what it does too is it challenges broad interpretation a little bit. The interpretation is being narrowed a little bit with this. Of course, if you've heard me speak, you in the audience, you know that court interpretation or judicial interpretation of law is one of my biggest complaints. That judicial interpretation is not really something that's constitutional and can be easily used in an evil manner. It can be abused very easily. But it seems like, based on what I've seen, while it doesn't say judicial interpretation is a bad thing or that agency interpretation is a bad thing, it does put a real muzzle on agency interpretation and narrows judicial interpretation. So in that sense, I think it was also a good ruling.
One of the it is a good ruling, and I'll give you two more opinions on it. One is from a guy named Roman Martinez. He argued on behalf of one of the fishing companies. He says, by ending Chevron Deference, this court has taken a major step to preserve the separation of powers and shut down unlawful agency overreach. Going forward, judges will be charged with interpreting the law faithfully, impartially, and independently, without deference to the government. This is a win for individual liberty and the Constitution. I think that's very well said. There's always we have an opposing opinion by Kim Meyer, and she's a litigation director of the Southern Environmental Law Center. So you can kind of guess her politics.
Yeah.
She says the Supreme, I think Kim is a girl. If it's not, I apologize, Mr. Meyer.
Well, we'll have to go look at the golf course and see if they're running. Yeah, I'm sorry. Go ahead.
I was going to say, maybe we should ask the Supreme Court whether Kim Meyer is a man or a woman. Do you think all 9 of them can identify what a man or a woman is?
Probably not. Well, we know that Jackson can't.
Exactly. By the way, he's talked about the 3, I would say leftist judges always ruling one favor. No, Jackson actually ruled. She had some pretty good opinions in the other cases.
I've noticed that, and this happened a couple times now, and I have to take back a lot of criticisms with her, because I've viewed her from the beginning as being about as dense as a brick, but then she surprises me a couple times, and this is one of them. Go ahead.
Yeah, I don't know if she just got a really good law clerk who's actually cracked open the Constitution once or twice, but whatever the case, she's been less of a disaster than we had feared, but still a disaster. Right. Yeah. What Kim Meyer says is the Supreme Court today says individual judges around the country should decide the best reading of a statute. That is a recipe for chaos, as hundreds of federal judges who lack the expertise of agency personnel are certain to reach inconsistent results on the meaning of federal laws as applied to complex technical issues. Once again, it's trust the experts. We know what we're doing. And, how'd that work out in things like, COVID? Technocracy is the rule by bureaucrats. It's been around. This was coming to power in the United States in the 1920s and 30s. Thankfully, it didn't gain a foothold. What happened was the Nazis were technocrats, and some of the abuses they did with medical experimentation were so abhorrent to morality that the technocratic movement in the United States disappeared for half a century. It came back to life in the early days.
And the technocracy on the surface, that's what it is. But deep down, what it truly is a plutocracy, which is where the money and the power of the money is really what's guiding everything. It's plutocracy by a different name is really what it is.
Yeah, and we live in a government. The United States government's the largest government in the history of mankind. It's the most powerful. They employ some, millions of people. It's like 2 million on the direct payroll, and gets up to 10 million if you count all the agencies.
Follow the money.
Yeah, that's really, everyone talks about the deep state, and it needs to be defined. This is the administrative. This is, part of the Leviathan known as our government. These are the people that are and it takes trillions of dollars in our tax dollars to function a bureaucracy this big, and it is a major problem. This is probably, you want to talk about draining the swamp. This is where it starts. And what is it, Agenda 2025, that what Trump's the conservative group that's put together a roadmap for what Trump should do, when he gets into office. And Donald Trump said he's going to, fire half the federal government. Well, he's going to have the authority to do some of that. And we can get into that.
I'll believe it when I see it.
Yeah, it didn't happen the first go round. Of course, he wasn't always getting the best advice. I think if he wins his second term, he's going to come in a lot wiser and smarter with perhaps.
But if he doesn't have the legislature in his favor, nothing's going to change. He has to have a legislature also to work with.
Yeah, and that kind of brings up something we were talking about after that debacle of a debate from Thursday night. Everyone's talking about replacing Biden, and the Democrats are all scrambling. Although I think it was a setup; they all knew it was coming. It was pretty hard. It's pretty hard to hide the fact that Biden was slipping. But I think what you're going to see happen is the left is going to pivot. They may not, they don't have a deep bench of potential replacements. They've got the Kamala Harris issue. How do you leapfrog Kamala in the pecking order? She was supposed to be this incredibly qualified, historical first woman of color to be the vice president, and she's next in line. I was on Twitter.
Yeah, and the next in line thing, I mean, from you went from Carter to Mondale. Mondale ran. Why? Because he was vice president. You went from Clinton to Gore. Why did Gore run? He had been vice president. Biden off of Obama because he had been vice president. This is the way the Democratic Party operates. The vice president's next in line and get the nomination. And we can go back to the 1800s even, and they were doing this. And then suddenly we have a vice president that's not supposed to be next in line.
How many vice presidents in American history have run for re-election after their president had been termed out or stepped down? Do you know how many have actually won?
Not many, I'm going to guess, but less so in recent. But go ahead.
I think it's Bush and Jefferson, and is the list.
Really?
Yeah, I went through that yesterday. I just did a quick glance. I didn't see another one to match. If there's a third or fourth, let me know. But I believe it was.
Well, we do have a lot of vice presidents, at least 7 that or more that stepped in, but not because of election, but because of death. So that happened more often than a vice president getting elected after the president termed out.
Well, it's interesting. Do you know how many times we've had a president that had at any period of time had to serve without a vice president?
Was it 14?
16. 16 times it's been a vacancy. 4 of those have lasted at least 3 years. And the longest, of course, being Andrew Johnson.
And the second longest being John Tyler.
Exactly. They never filled that vacancy. It shows you how important the vice presidential position is.
Well, prior to the 20th Amendment, there really wasn't a process established constitutionally to replace the vice president. And so it was guesswork on how to do it. The 20th Amendment then established that the new president would nominate if there was a vacancy in the vice presidency, and then both houses of Congress would need to approve it. That wasn't established till the 20th Amendment, which I can't remember the exact date, but I believe it was the late 40s or 50s. So prior to that, there really wasn't a process constitutionally, is my point.
20th Amendment was
1933. Goes back further than I thought. Yeah, I just looked it up myself.
So just, I think we're going to wrap up with these 2 cases and get the other ones because we're past an hour, and the other cases we want to jump into deserve a full deep dive. I don't want to.
That first case took like 45 minutes, but it was important.
It is important, and I want to put it in. And I want to bring this home and put it into perspective of what a big victory this was for individual liberty, and making the largest government in the history of the world a little bit smaller. The president of the United States comes in there, and he basically is in charge of 2 million federal employees, and he gets to put in the heads of all of these agencies are political appointments. This is an awful lot of authority, a lot more authority than the executive branch was ever supposed to have when they're out there making rules, basically legislating, and then adjudicating. And the ability
doing so domestically, domestically was supposed to be minimal. Federal government was created for the external issues, not the internal issues. So, and now we've got this domestic Leviathan who's dictating, and the states at this point are practically nothing more than provinces.
And of course, these employees are almost impossible to fire. Mm-hmm. They've got federal employee all kinds of protections. They get lifetime pensions, which are much more than the private sector, and that's all happened in the last few decades.
Right.
I remember. I've been trying to find this graphic again, but right around 2003 or 4, I saw a chart that basically showed the demographics around the country and basically average income earner. And Washington, D.C. was like 9th on the list in the D.C. metropolitan area. Now it's number 1. You want to get rich, you go to work for the government. And that's not the way it's supposed to be. It's supposed to be the private sector.
Right.
So that's why we brought up these are the first of the cases we wanted to talk about because they're that important. And again, it's a big deal with these 2 decisions happened. So, Doug, where can everyone find you?
DouglasVGibbs.com. And in the coming weeks, I will start writing and doing videos a lot more than I have been. I'm in a currently I'm in a kind of a flux and changes, but I'm going to be landing on my feet in the next week or two, and then it's no holds barred. We're going to increase all of our activities. And so DouglasVGibbs.com. Don't forget that if you want to help fund what I do, become a patron. $9 a month allows you to be a part of the movement that I am steamrolling forward.
Very good. You're probably watching this video on my main channel on Rumble, which is War Hamster. You can also find me on Twitter at war_hamster1776, on Truth Social at war_hamster. I too am about ready to really pick up my activity, especially heading into the election. Doug and I have promised we are going to start doing a live stream at least once a week to get started with it. And we'll be doing more of these one-off video recordings, like we'll be doing probably about 3 more of these on these recent Supreme Court cases. And because there's a lot of big stuff to talk about.
Sure.
So as soon as we find time in our busy schedule, the next couple of days, we'll go out with round 2 of this. But until then, thank you, everybody. I hope you enjoyed it. Feel free to share, like, and absolutely leave comments in the section on the video down below. I do a pretty good job of getting back to people, and give us suggestions of what else you'd like to see us cover. So thank you very much, and have a great weekend.